Thank you, Mr. Speaker. And Mr. Brown, thank you very much for your leadership on this effort. All that needs to happen, it's often has been said in the past that all that needs to happen for good government to go bad is for good people to do nothing. And I want to congratulate you on the goodness that you're doing tonight in organizing this effort to bring to the American people the full blush and the full pain that C.A.F.T.A would really offer us. You know, it's been often said and cheered throughout this world that we live in that the United States is the standard of living to be desired by everyone, to be cherished by everyone. Standard of living that is second to none in the world. And I think Mr. Davis from Alabama's remarks relative to some of the globalization efforts that are so present in the C.A.F.T.A agreement is the one very reason that I'm against it. Because this globalization effort is a race to the bottom for the United States. We have nothing to do but lose in this agreement. There's not one thing that we can gain, because it is, as many have already said before myself, it is a race to the bottom, and it is a replay of NAFTA. And all you need to do is take a look at the chart up front, and I hope the cameras can give that some FaceTime. C-SPAN can give that some FaceTime, because it's important to look at and see exactly what happened after we adopted NAFTA. And we were told in NAFTA in the early 90s that we were going to have this tremendous explosion in exports from the United States to Mexico, and that we were going to be able to increase, at that time, what was a positive trade agreement with Mexico. Well, you can see exactly what has happened starting in 1995. We continued to drop down until today we're at roughly $40-some billion in deficit trade with Mexico. And that's precisely what we're going to see happen with C.A.F.T.A. Thomas Jefferson once said that he had but one lamp that illuminates his path into the future, and that is the lamp of experience. I have no way to judge the future except by the past. Well, if NAFTA is the judge, the measure that we have to judge ourselves by on our success and what we can expect from C.A.F.T.A, I can tell you, folks, it isn't near as bad. It isn't near as bad as it's going to be, because C.A.F.T.A has some unique features all of its own. And in his introduction, Mr. Brown mentioned that I had a new twist that I was going to put on it relative to sovereignty. And I just want every member of this House, all 435 members of this House, I want them to be prepared when they go home and explain to their folks at home exactly what they've done for whatever amount of the 435 members vote for C.A.F.T.A, and quite frankly, in selling down the drain the sovereignty of this country. You see, under our C.A.F.T.A agreement, it's interesting that C.A.F.T.A is a pretty good-sized document. I'm not going to lie to anybody and tell them that I've read the entire thing, but I'll tell you what, I have read the trade part, and that was about 20 pages. The next almost 1,000 pages is international law. And the international law is what's going to prevail in any business agreement that we have with these 5, quote-unquote, fledgling democracies under the C.A.F.T.A trade agreement. And here's what happens. If I happen to sell something to, say, the Dominican Republic, if I happen to sell something to the Dominican Republic from one of my entrepreneurs in Idaho, and they get into a conflict of what the agreement was, or in one way or another, this has to be settled by a third party. Here's exactly what happens under the C.A.F.T.A rules. The Dominican Republic would submit the name of one arbiter. The United States would submit the name of one arbiter. And then, here's the punchline. One of the other non-involved members of the C.A.F.T.A trade agreement get to submit a third arbiter. So now what we're going to have is 2 Caribbean Basin members and 1 United States member serving on a court of arbitration in order to solve this problem. Now, if that doesn't happen, what happens? If these folks can't come to agreement, then what happens? If this tribunal can't solve it, then we go to the World Bank or we go to the United Nations to solve what is otherwise a business agreement. Now, it's interesting that the best place to be in this agreement is not in the United States. And we're told constantly that we're going to be opening all these countries up. If we will just pass this trade agreement, we're not going to be having the duties and the quotas and everything that stop all our goods from freely being imported into these other countries. Dead wrong. Number one, there are a lot of duties and quotas that will go away. But there's still quite a few that are going to last into the next 20 years. So we're still not going to be on a fair and equal trading level with the other members of C.A.F.T.A. But let's take a look at who put all of those duties and quotas in place. In 1984, this Congress passed what's called the Caribbean Basin Initiative. And we said, as long as you add 28% of the value to whatever good or whatever value-added item that you have in these Caribbean Basin countries, you can come into the United States with those products without quota and without duty and without fees. However, the United States didn't have the same agreement going back. And so we've done this to ourselves. And yet now we're saying we're going to try to clear all this up with C.A.F.T.A. I agree with you, Mr. Brown. I agree with Mr. Davis from Alabama. I think what we ought to do is go back and repeal the Caribbean Basin Initiative and then start from the get-go. Then we can say something to them about their environmental concerns, our environmental concerns. Then we can say something to them about the unequal labor laws or labor practices in the relative countries. But as it stands now, we simply don't have the opportunity to do that. So there is one area that I would like to pay special emphasis to. And I know a lot of people have said to me, they've said to me over the last couple of weeks, oh, but you know, you're way over concerned about the C.A.F.T.A. agreement and what it's going to do to the sovereignty of the United States. I say to this to you, that I've stood here on this floor and I've watched every member on this side of the House and many members on the other side of the House that have voted against any attempt to take one of our warriors that's fighting the war for freedom in Iraq or Afghanistan or any foreign country, and any attempt to put them before any kind of a tribunal outside the United States, we have resisted, and correctly so. Yet these are the same people, the majority of which now is willing to offer up our economic warriors to international tribunals. It seems terribly inconsistent to me that if it's correct to deny the courts, any foreign court, to hold judgment over our soldiers, it ought to be the same way with our trade agreements. But anyway, I would direct everybody's attention to Article 10. Just read Article 10. Beyond its plain language, we've now got hard evidence that the C.A.F.T.A. tribunal system would work in real life and how it would create real advantages for foreign companies other than the United States. Because a similar system was established in N.A.F.T.A., and that's the one that I would like to draw your attention to. And a case was brought under that system in Lowen versus the United States. And this has set a legal precedent that should scare us all. In that case, a Canadian funeral home conglomerate named Lowen challenged the judgment of a Mississippi state court that ruled against it in a private contract dispute with a Biloxi, Mississippi funeral home. The only government action in question was the normal function of a state court in a private business dispute. The Canadian company, under N.A.F.T.A. rules, claimed that having to follow the standard rules of U.S. civil procedure in court, such as posting a bond, violated their N.A.F.T.A. foreign investor rights. And you know what? The World Bank Tribunal in that case ruled that the state's court's normal operation was, quote unquote, governmental action, unquote, and therefore regulated by N.A.F.T.A., and that its conduct violated the Canadian conglomerate's special N.A.F.T.A. granted investor rights. It's just tenfold that bad in C.A.F.T.A.